Good evening, everyone, and welcome to this webinar on the challenges and tips for success for arbitration in the online environment. This webinar is sponsored by AUT and brought to you by the Arbitrators and Mediators Institute of New Zealand, of which I'm the Executive Director. My name is Sue Wells. I'd like to thank you all for joining us tonight, and also to thank very much our sponsors who make this possible this evening. We've been very grateful over the years for the sponsorship of AUT in bringing us events, in particular of the Young Arbitrators Group, which has this year been co-convened by Emma Peart and by Sam Jeffs. Sam is unfortunately a victim tonight of technological duress and cannot join us. He has put an enormous amount of work into bringing this together, as has Emma. And this evening they will be interviewing, or Emma will be interviewing, Bob Fisher, Lauren Lindsay, and from London, Ravi Jackson. I'd like to hand over at the outset of this to Vernon Reeve from AUT to say a few words. Vernon is the Associate Professor and Associate Head of School of External Relations for AUT. Vernon, thank you so much for being here, and thank you for sponsoring this webinar. Over to you now.
Thanks so much, Sue, and good evening, everyone. And I'll be brief because I'm sure everyone's keen to get on with what looks like an excellent and incredibly timely webinar. As Sue mentioned, the law school at AUT has had a long and rich partnership with AMINZ, and it's a relationship which our Dean, Sir Charles Rickett, and all of the staff at AUT value very highly. The law school's support of the Young Arbitration Group, I think, reflects a particular view of the importance, first, of dispute resolution outside of the traditional court system, but secondly, of getting early career lawyers involved in the practical aspects of the profession, where they can rub shoulders with practitioners of the calibre of the presenters in this evening's session, and also to learn from each other. And we saw that with last year's biggest mistakes in arbitration event at AUT, and I'm sure this evening will be just as inspiring. So, thank you again, Sue, to Terry for the administration and for organising this. Congratulations to AMINZ for putting on such a great event, and best wishes to you all. And now I will hand over to Emma Peart, who I think is our web MC for the evening. Thanks, Emma.
Thank you, Vernon. So my name's Emma Peart, and I'm a Senior Associate at Minter Ellison Rudd Watts, and along with Sam Jeffs of Bankside Chambers, I'm one of the co-conveners of the AMINZ AUT Young Arbitration Group. So, the topic tonight. Well, as COVID-19 continues to impact the operation of our courts, arbitrating, particularly via audio-visual link, may be a potential way forward to resolve parties' disputes in a manner which is safe for all involved. But arbitrating, or indeed conducting a trial in court remotely, is not without its challenges. How does a decision maker make findings of credibility? How do legal teams work together when they are physically separate? And as advocates, how do we adapt our techniques to effectively put our client's case through a computer screen? Our speakers are going to discuss these issues and their tips for success during this webinar. If you have any questions, please enter them in the Q&A box, which you should see at the bottom of your screen. You can enter your questions at any time, and I'll put them to the speakers at the end of the webinar. So now I have the pleasure of introducing our amazing lineup of speakers. We only have an hour for the webinar, so I'll keep these very brief. First, the Hon Robert Robert Fisher QC will be well known to many of you. Since retiring as a judge from the High Court in 2004 after 15 years on the bench, Bob has been a full-time arbitrator and mediator at Bankside Chambers, as well as an appellate judge in a number of South Pacific states. Second, beaming in all the way from London is Ravi Jackson, a barrister at 3 Verulam Buildings, or 3VB Chambers in London. Ravi was part of the recent 3VB team which successfully aided for the claimants in a remote trial of a $530 million financial list dispute, with acting for the National Bank of Kazakhstan against the Bank of New York Mellon. This is thought to be the first fully remote financial list hearing, and involved the judge, counsel, solicitors, and both factual and expert witnesses participating via video link from their homes in England, Belgium, Kazakhstan, and the United States, which must have made coordinating the time zones very tricky. And our third speaker is Lauren Lindsay. Lauren's also a barrister at Bankside Chambers and a fellow of AMINZ. She rejoined Bankside in November 2018 after spending 8 years at Allen & Overy's international arbitration team in London. So, without further ado, Bob, I'll hand it over to you.
Emma, I think your reference to AVL being a challenging environment is pretty timely. And Ravi, I hope you don't mind if I use Boris Johnson as an example of why we do need to learn something about AVL. He had his first cabinet meeting via Zoom. He was so proud of this that he instantly twittered the picture that you see before you, along with the announcement that he had chaired his first ever digital cabinet. And a wag the next day said, if you'd like to dial into the cabinet tomorrow, the Zoom meeting ID has helpfully been included in this screenshot. And what Boris hadn't realized was that if you look up at the top left corner there, it gave you the meeting number. And of course, there were other ways of shielding cabinet meetings, but it was an amusing example of someone venturing with more enthusiasm than knowledge into the field of AVL. My own view is that the future of AVL hearings in New Zealand and elsewhere is very strong. To start with, the AVL is going to continue long after COVID has ceased to influence us. I think to start with, there will be quite a lengthy period with ongoing border controls, which will mean that when we have a witness in Canada and a party in the UK wanting to take part in a hearing in New Zealand, they're not going to be very keen on 2 weeks quarantine. But more importantly than that, COVID has introduced us to the benefits of audiovisual link hearings, and we're going to be reluctant to give those up. And there has been, of course, a permanent step up in understanding and using instruments like Zoom, which we're all on at the moment. The second thing is that there is a debate going on, predictably, between the traditionalists and the innovators, which always goes on whenever there's any proposed progress in procedural arrangements. We don't have time to get into that debate, but some of the arguments for courts, such as the courthouse being a physical symbol of the majesty of justice, everyone's entitled to their public day in court and so on, don't apply to arbitration in any event. I think the next point to make is that there's nothing new about remote hearings, that we've been using them for overseas witnesses. I remember 25 years ago having a witness in Singapore joining us by audiovisual link in a High Court hearing in New Zealand. We, of course, have phone conferences routinely, both in court cases and arbitration. We've been using AVL for remands in the district court, interlocutory matters in the Court of Appeal, and so on. So the shift to running a full audiovisual link hearing is, I would say, simply another step along an inevitable track. The topics that I just want to discuss are the joint preparation for an AVL arbitration, preparation by individuals for an AVL arbitration, and then finally assessing credibility during an AVL hearing. And I'm not going to go into advocacy during the hearing because Ravi and Lindsay will be dealing with that. Lauren, sorry. So if we go back to joint preparation for AVL arbitrations, obviously there is a huge amount of cooperative agreement and organisation goes on for any arbitration. But with AVL, it does add an extra dimension to this joint preparation because we need to agree on the technology that's going to be used, how it gets used. We can't find the procedures in a set of rules or in conventions that have grown up over centuries as to how court cases are conducted. And there's a lack of technical familiarity for some lawyers and decision makers. So all of that means that in the preliminary meeting and in subsequent conferences, we have to consult and put in a great deal of time to set up an AVL arbitration in the right way. It's time that we won't need as everyone gets more used to it, but it is still time that's required. And it has to be done by agreement. Sadly, the days of being autocratic from the bench don't really work in an arbitration environment. I think that to the joint preparation that is required for every arbitration in any event, we're adding another 4 steps. One of them is that we have to choose the systems of document management, AVR platforms and hosting, of which there is a wide range available to us. Secondly, we have to check that every participant in the process is going to have a reliable connection. Thirdly, we have to determine the way in which the AVL is going to be used during the hearing. And finally, we have to test the AVL system before the hearing. So far as choosing step 1 there, which is largely technical, first of all, we have to choose a document management system that's going to work alongside the audio-visual platform so that the two work well together. I happen to use Dropbox at the moment, but of course there are other off-the-shelf systems for organising documents, which may well be just as good. There is litigation support software, and I've mentioned a couple of examples there, but they are directed primarily towards e-discovery. My own experience is that carrying through that sort of software into the hearing as a basis for finding and locating exhibits doesn't really work at all well. The Rolls-Royce system, and Ravi will be very familiar with this, is called case lines. I would love to have an arbitration where case lines could be afforded. To show you how popular and effective it is, it's used by the first instance courts throughout the UK, used in Canada, South Africa, Middle East. Those are courts that we're talking about, but it's available for arbitrations. The only thing is that it costs 60 cents per page that you input to the system. But if you could afford it, it would be wonderful. It takes the whole case from go to woe. It allows you to have your own private annotated copies of everything. that other people don't get to see, and so on. But for lesser mortals like myself, most of us need to combine a document management system such as Dropbox with an audio-visual platform. So Zoom, of course, is the one that we're most familiar with and that we're working on at the moment. It has a reasonable level of security despite the publicity given to Zoom bombing, as it's called. To combat the unexpected and unwanted arrival in Zoom processes as a password, people go first into a waiting room. If you set it up that way, there is a transparency of who the participants are, and there is encryption, which goes a long way towards security. I think the other main competitor, as far as I'm concerned, although Wikipedia lists 34 different programs, believe it or not, that are available, but the other interesting one is Microsoft Teams, which may well be better than Zoom in that it appears to have all the functionality of Zoom, but it integrates the document management and the video conferencing into one system, which, all else being equal, sounds good. I think the third technical thing to decide at the outset is who hosts the system. And this is going to be affected by the magnitude of the arbitration and therefore the resources that can be put into it. But the arbitrator and/or the staff of the arbitrator in New Zealand would normally set up and run the AVL hearing. It can be organised by the solicitors for one of the parties, but that seems to me to be undesirable, although I have tried that. There is institutional support, for example, NZDRC, which using Zoom is happy to run and case management a case for arbitrators and the parties. And there's also a very good system being run by CODA, which uses a Sweetbox, which is essentially primarily a screen sharing system. And then I've put there also the New Zealand courts. The appellate courts in New Zealand have a new system which they're calling virtual meeting room. I don't know what ingredients have gone into it. It's only available for appeals. They describe it as a web browser-based video conferencing system supported by the Ministry of Justice and Spark. Just how much that inspires you with confidence, I don't know, but we'll wait to see. For first instance cases, apparently are going to trial Microsoft Teams. Well, once you've got the technicalities set up like that, I think the next and vital thing is to check that every participant in the AVL hearing is going to have a reliable connection. Because the best AVR system in the world is going to fail if one of the participants has a poor connection to the internet. And you hear huge criticism of AVR systems and how often they have broken down, including a few weeks ago, an attempt by the Court of Appeal to run an AVL system. And in nearly all cases, it comes back to the fact that one of the participants has a poor connection to the internet. In that case, it was one of the judges trying to do it from his house and in the end had to rush into the courtroom to get a decent connection. So that is absolutely vital, and I've had lots of personal experience, and I'm sure you have as well, of these systems breaking down because someone's fading in or out. You can see them, but you can't hear them, and so on. Now, the best connection is always going to be a dedicated AVL room. That's a room that's set up with AVL in mind, with a big screen at one end, a wide angle camera, a very strong connection to the internet. So you'll find that big solicitors firms and accounting firms and some barristers' chambers are able to provide that. But particularly under our COVID regime, you're not going to be able to get everybody into a room like that, or even 3 rooms like that. They're probably all going to be working from individual PCs from home and elsewhere. So if they are reliant on personal connections, they need to have either an Ethernet cable connection or a strong Wi-Fi signal. It seems to me that it's unwise to rely on the cellular network. The next thing you need to prepare in advance, and this is all done jointly, is to determine the way in which AVL will be used during the hearing. There's a myriad of details to sort out there in advance, but probably the biggest single one is exhibits, what sort of electronic bundle you have and how you access it, and also a procedure for admitting new evidence, new exhibits, which inevitably come in during the hearing, no matter how comprehensive the initial electronic bundle may have been. You need to agree on who controls the screen share process. A screen share, I should say, is the opportunity for one of the participants in the meeting to have the screen on their computer seen by everybody else. So that's something that I'm doing at the moment. I'm showing you something that's going on my computer. And so any particular lawyer dealing with a matter at a particular time, such as cross-examining, is likely to control the screen share, and you need a process for transferring that control from one participant to another. You need to agree on a witness room protocol, or coaching them, or in some other way, some sort of skullduggery. And so that can be dealt with by laying down the rules for that. And there are other details like shorter hearing days and longer breaks to take into account, I think, for me at least, a higher level of concentration is required in an unrelenting way while this is going on. And as well as that, you need to allow time for technical hitches. The last thing in the way of joint preparation, it seems to me, is to ensure that you have at least one joint trial run. I myself think that if you're going to head towards an AVL hearing in the arbitration, you should run all the conferences, even the preliminary conference, and in the interlocutory hearings in the same way, so that everyone gets used to that system. But familiar or not, you need a full dress rehearsal before the substantive hearing with lawyers at least, and the arbitral panel, and have a run through to make sure that everything works. Now, the next thing I was going to talk about was individual preparation for AVL arbitrations. Like the joint activities, there's a huge amount of preparation, obviously, that any lawyer will carry out before any sort of arbitration. But to that, you need to add a few extra items. The personal tech system you adopt. I'm a great fan of having multiple screens, for example, and more than one device. Secondly, learn and practice the tech system. And if there's time, we might come back and talk about some of these things. Thirdly, you have to prepare an adequate visual setting, which means that you want a background which isn't going to be distracting and ideally not embarrassing. You want to prevent background movements which detract, and you want to try to get a reasonable view of your face. I think ideally everyone should, if they're not in an AVL room, it's better to give everyone a separate device and a separate screen, and they're easier to control. And the last thing I'd suggest under this heading is make sure there's a reliable wall between the scene and the private documents. So I personally would always have separate devices so that you don't accidentally share the wrong screen with everyone else and they see all the derogatory remarks and confidential cross-examination notes and so on. The last thing that I said I would talk about is credibility. There's really not a lot that needs to be said about that. In a sentence, AVL hearings don't suffer from any reduction in the opportunity to assess credibility, in my view. All the usual tools for assessing credibility apply, and I've set those out there, but in order of descending priority, we don't really have the time to go through those, but the main point is that they don't differ in any way from the tools that any decision maker would use in deciding on credibility, whether it's an in-person or AVL hearing. There are special steps that you can take to ensure the witness is visible and unprompted. And the third thing is that demeanour doesn't help us to assess credibility anyway. I put a very long quote there from a learned American professor who summed up all the literature on that over a period of 50 years. And then, unforgivably, I've thrown in a reference to my own article on that topic. But I think that's enough from me at this stage. And over now to Ravi.
Thank you, Robert. Well, thank you everyone for attending this seminar, and thanks to Emma and Stan for organising it. I hope that you can all hear me clearly. I'm sure if you can't at any point, I'll be flagged down or sent a chat message. As Emma said, I'm a barrister at 3VB Chambers in London, and I was involved in a case in London which became the first trial in the UK to be conducted entirely remotely. I'm going to speak on 3 topics using my experiences of that particular case. The first is cross-examination of witnesses. The second is working as a legal team remotely and how you go about doing that. And the third is my overall impressions of the position in the UK and the future use of these sorts of technologies. So just to give you some brief info on the case, obviously I won't discuss the merits of it, but as by way of background, it was a multi-party financial list dispute for a sum of around $500 million between Kazakhstan and various other parties, and it arose out of attempts to enforce an arbitral award. The trial was due to start on the 23rd of March, and in the run-up to that date, obviously things got a bit more serious. Government restrictions and measures kept increasing in severity, and finally lockdown was imposed in the UK on the 23rd of March. So the trial couldn't go ahead as originally planned. We had to do some quick thinking in the time we had available to us, and that involved our solicitors, liaising with the other side's solicitors and trying to work out what technological arrangements we would put in place. And the particular difficulty we had was that this was a multi-jurisdictional case. The judge, counsel teams and solicitors were based in London, but we had one factual witness in Kazakhstan, and we had expert witnesses in Belgium, the United States, and again, Kazakhstan. The technological arrangements we ended up using were Zoom, as we are now, and we had a participants room where we had the counsel team, the judge, the witnesses at any given time and transcribers in that room via Zoom. And the solicitors and clients and members of the public watched via a live stream on YouTube. So that, in overview, is what we had in place. Obviously, there are many different ways to do this. In the UK, at least, Zoom and Skype for Business seem to be the most popular options, though there's been rumblings about switching to Microsoft Teams in the future. So the first topic, cross-examination of witnesses. The question here really, I think, is what has changed? Do these audio-visual arrangements actually change your examination of a witness at all? I think my answer to that is that relatively little has changed. In terms of the substance of the questioning, that remains the same. So you prepare in the same way, the line of questioning is the same as it would be in the courtroom. It's just the medium through which the questioning is being delivered that's changed. Now, a couple of technological issues that one might run into. Robert has already mentioned the idea of having a witness room protocol. So at the start of each examination of a particular witness, counsel will say, can you just confirm who's in the room with you, what they are there for, etc. And that's something that happened in our case. And it's very straightforward. The witness will confirm who is there, what they're there to assist with, and usually it's turning over the documents. The next point is connectivity issues. And again, Robert's already mentioned this. Happily, in our trial, everyone seemed to have a reliable Wi-Fi connection, and everything went off pretty much without a technological hitch. But I can well see that if you don't have that, and if you're relying upon a poor Wi-Fi connection, that could impact the smooth running of the trial and be very frustrating. The perhaps two technological issues which did arise in our trial, but were relatively minor, is one, the sound quality, and two, muting yourself. So the sound quality, everyone needs to have a good set of, either a good laptop that has a reliable microphone on it, or a set of headphones which they can use. What you tend to find is that because some advocates are used to moving around, they might lean forward into the screen and then lean back and then adjust some papers and look at another screen. And sometimes the sound quality is lost, whereas you want a good, consistent sound quality. Not muting yourself was perhaps the biggest technological problem, although as I said, it was minor in the grand scheme of things. When one's examining a witness, it's very easy, once you've asked the question, to shuffle your papers like you would do in court and find your next question. The problem with that on at least Zoom is if you don't mute yourself, then it may pick up the sound from you shuffling your papers, and that may completely steal the sound from the witness. And obviously, if you've got transcribers there who are trying to take down what the witness is saying, that may be completely lost. That's a particular problem. I expect that's a teething problem, really, because as people get more used to using these types of audiovisual technologies, they'll get more used to muting themselves. But that is one to be aware of. The next point, I think, with cross-examination is credibility. And I'm rather of the same opinion as Robert here, in that I don't think it's so much of an issue. It seems to me this point really relates to demeanour. And as Robert said, demeanour isn't a particularly useful way of assessing a witness's credibility, provided you can hear their answers and provided you can gauge the reliability of those answers in the context of a case as a whole, then that's the most appropriate way of judging credibility. And finally, on cross-examination, the trial timetable. Now, in our case, obviously we had witnesses from different jurisdictions, and we had to make sure that they were prepared at the relevant time in their jurisdictions to be called to give evidence. It's a fairly easy issue to resolve. Our solicitors were very proactive and just said, you need to be, I see there is an echo in my voice, so I will slow down a bit as suggested. Thanks for that. It's really a matter of the solicitors making sure those witnesses are available between certain time periods, so that if they have to come on at any given time, they can do so. One thing about the trial timetable in general is that it does take, I think, a bit longer conducting an audio-visual trial than it would a physical trial. So you may have to build some wiggle room into the trial timetable that you wouldn't otherwise have. The second topic, working as a legal team remotely. The first point is on bundles. Now, in our case, we were quite lucky because just prior to lockdown, everyone had been delivered hard copies of their bundles. So we had those available to us and we didn't have to use an e-document management system. But obviously that won't be the case for a lot of trials going forwards. Now, there are various services like Magnum Opus out there which one can use, and my experience of them has been so far very good. They are quite intuitive to use. And as Robert has already referred you to, there is a useful function on Zoom and also on Teams, I believe, where you can share a particular document on screen and you can have that viewed by the court, by the witness. And I have to say, we found that very useful in our case. Say, for example, a judge mentions a particular authority that no one has referred to yet. Well, you can quickly do a Google search, put that up on screen for all the court to view. So I thought the document management side of it was actually very, very useful. The next point is in-trial communications between counsel and counsel, solicitors and client. What we did, and what I understand has now become very common, is that we used WhatsApp to communicate mid-trial. And that was quite an efficient way, I thought, of communicating. So in lieu of the normal passing of the post-it notes, you'd simply send a message to a group. Obviously, you have to be very careful that you're sending the message to the right group. But happily, that was all fine for us. One point, which is a technological point, is that it's useful to download, if you are going to use WhatsApp, the WhatsApp web app onto your computer so that you can have it up on screen. That's a bit more noticeable than having it on your phone, where you might not see the notification and where the court might see you looking at your phone and think, well, they're not that interested in this trial. But other than that, I think working as a legal team remotely was very easy. We've continued using, certainly my chambers, continue using Zoom and Microsoft Teams post-lockdown to do collaborative working, to have conferences and conduct cases. And I think it's actually a very useful tool that people use going forward. That leads on to my final topic, which is my overall impressions. Robert mentioned this idea of traditionalist versus innovators, and I am firmly in the innovator camp. I think this is very useful technology that will be used in the future. And what COVID-19 has done is given everyone the impetus and the necessity to use it. I think for trials, physical hearings are probably preferable, although I expect there to be more document management using e-bundles. But for short hearings, for interlocutory hearings, and for cases where you have international witnesses, I think that this could and should become the new norm. Just to give you my view on the UK position, certainly the guidance from the senior judiciary here has been that in the current crisis, all, or at least all participants, or at least some, in a trial or in a hearing will be joining the hearing via audio-visual technology. And there's no reason why that shouldn't continue beyond the current crisis. So I hope that was useful. I'll now hand over to Lauren.
Thank you very much, Ravi. Tēnā koutou, tēnā koutou, tēnā koutou katoa. Warm greetings to you all, and thank you very much for joining our Young AMINZ seminar. I was so pleased to hear that Bob, Ravi and I all are in the same camp, and that we're in the innovator camp, and that will become clear from the points that I make during the next 10 or so minutes. So in my part of the talk, I want to address 3 topics. I'm going to briefly talk about the protocols that exist in New Zealand for remote hearings, which have arisen since COVID-19. I'll touch on some general skills that you might need in an online environment for a hearing. And I'm going to finish by talking about remote hearings specifically in online international arbitrations. There's a few additional points that I'll add to what Ravi's just said about his remote litigation. But before I get to my topics, I just want to make 3 preliminary points to share with you some thoughts that I have about remote hearings generally. So the first one is obviously the catalyst for this and other discussions that are kind of exploding on the web around virtual hearings is obviously COVID-19. And in this new world, many of us are practicing social distancing, and we're in some places like New Zealand or Australia and in the UK, we're isolated in our own bubbles. But I think we should bear in mind that that's not going to be forever, at least hopefully. And so when we're thinking about remote hearings and whether they're going to work in the long term, in the future, we shouldn't really be focusing on the circumstances in which we find ourselves now. In the future, remote hearings will look very different, hopefully. And I think one of the issues that Ravi was talking about, and certainly is a concern generally, is how you prepare as a legal team when you're each in your own house and can't get together. In the future, without COVID-19, we'll be able to do that. We'll be able to get together, have a hearing. Hopefully the legal team can be in one place, and then you just have your tribunal somewhere else or your witnesses somewhere else. My second point is about innovation generally, and I really do think we should question rigorously what Bob refers to as the traditionalist school of thought that is resisting remote hearings for commercial matters. And I'm leaving to one side criminal litigation because I think in that area it's quite different and the concerns are rightly different. But I do wonder whether our concerns with remote hearings really stem from our concern about acting in the best interest of our client and doing the best job that we can as lawyers and ensuring that a hearing is fair. Or is it a little bit more about our identity as advocates and how we see ourselves? A lot of us have an image of ourselves as the hearing room advocates on our feet, making the killer point, eyeballing the witness. And many of us live for that adrenaline, and it's not really the same if you're doing it in your home, half in your pajamas, and wearing a very naff headset because you can't afford fancy Apple earbuds. And I'm not saying that concerns around remote hearings are not valid. I just think that the discussion should be about what remote hearings should look like, because they are here to stay, what they should look like in order for them to be fair, not what they currently look like now. And in that sense, we should focus on the enormous benefits for our clients and to the planet, the enormous cost savings and obviously less pollution because of the decreased travel. And this, as an international arbitrator, is a real issue in international arbitration and something that's becoming a real topic at conferences about our own footprint. And my final point before I talk about my topics is that we're not yet experiencing remote hearings in a 5G world. We've all heard a lot about 5G technology in the news, and it's a constant thing as it's being rolled out around the globe. But 5G will be a completely transformative experience. And at the moment, we don't really have the applications ready, such as driverless cars, to really use 5G. So even where 5G has been rolled out, we're just using it as we would 4G. With 5G, we'll have exponentially faster downloads and upload speeds, and it'll enable billions of devices to be connected globally. So in this future world where we can remotely control construction sites, I personally think that we'll be able to navigate online hearings very effectively. So on that, video hearings, I think, like Bob has said, are here to stay. They will look very different in the future. And as lawyers, we should really embrace the change and ensure that we're part of it, so that we can ensure that any concerns about fairness are properly addressed on the way through. So those are my thoughts that I just want you to bear in mind as I talk about my 3 topics. So my first topic is the New Zealand Supreme Court and Court of Appeal Hearings Protocol. Many of those that have tuned in to listen to this webinar will be aware of this protocol. It was put in place after the pandemic was declared. And I just think it provides quite a robust starting point for discussion around remote hearings, whether they're court hearings or arbitration hearings. And interestingly, the protocol is mostly practical. And both Ravi and Bob have touched on some of the practical guidance. I would reiterate the do a test call guidance that is in the protocol. And I think also in the international arbitration context, a test call is a really great icebreaker because you have your tribunal there, opposing counsel, you don't have to be in formal attire, and you can just make sure everything's working. I'll just quickly mention some of the things in the protocol because I think they're back to basics for advocacy. So things like speak directly into the microphone when addressing the court, be familiar with how to mute your microphone and turn your video off, so that one's for Ravi. Mute your microphone when you're not speaking, also for Ravi. Speak more slowly than a normal courtroom pace. I struggle with this because I'm a very fast speaker, but obviously when you're doing things remotely, you do need to speak slower and as clearly as possible. So those guidelines, if you like, are kind of a good starting point. And I'll move to my second topic, which is to talk about remote advocacy generally and some tips. And I think similar to what Ravi and Bob have already said, there's no magic to this. I don't see remote advocacy being that different to advocacy in person. As with all advocacy, preparation and practice are key. Personality is of course really important, and I'll come back to that because I do think you lose some non-verbal cues, and that has been shown through the research when you're communicating through video. But fundamentally, remote advocacy just means focusing on the basics. As I've said, you have to watch your pace even more carefully than usual. And with cross-examination, I think one of the things, I completely agree with Ravi, you would have the same questions, but you would just make sure your questions are short and simple and closed, but you should be doing that anyway. As Bob has said, I think preparation could be just that little bit more important in an online context, particularly if you haven't done an online hearing before. And if you're making submissions remotely for the first time, you have to accept that will be an unfamiliar setting for you. So as the advocate, just think, how are you generally reliant on your team in that context? We've talked about documents. You normally have someone get a document for you, help you find authorities. You have to come up with a plan in advance for how to deal with those situations because that person won't necessarily be next to you. And as Bob's already talked about, make sure that all your IT equipment's working, you know where your gadgets are, what screens you're going to use, all that stuff. I think you should also give particular thought to your appearance and how you're delivering your message. So there is actually some quite interesting research about non-verbal cues, particularly in the area of online mediation and virtual negotiations, where building trust is very important. INSEAD has done some research around this, and they show that actually when you're in an online environment, the person listening to you, so say your decision maker in an arbitration context, your tribunal, they have to work harder to understand you. That's because we communicate through both verbal and non-verbal cues. And this is not, you don't sit there thinking I'm working harder, but you actually are working harder without realizing it. And I think that comes back to Bob's point about having a few more breaks during the day and sitting for a shorter period of time. And the other point that I found quite interesting in the INSEAD research is about silence. As an advocate, that can be a real skill to know when to pause and to let the silence fill the room. It's that natural rhythm that you have in a conversation. But they've shown that online, silence makes people feel uncomfortable because they think there's something wrong with your connection and people get really anxious. I think over time, as technology improves, this won't be an issue, but it's just something to bear in mind. And the other thing that I mentioned before, the protocol talks about, well, I didn't say this, but in the protocol in New Zealand, you're supposed to be as still as possible. But someone like me, you can see I'm moving as I talk, but that's also just who I am and how I communicate. So INSEAD would say, actually, you should make sure that when you are giving submissions or negotiating through video, to let those that are watching see you a little bit more, so from the waist up, for example, so they can see your hands and pick up on that kind of more natural interaction. And one point that I find quite interesting, I've heard a practitioner say that in online hearings, this was in an international arbitration context, participants, particularly witnesses, don't feel like it's a real thing, and they may not appreciate the importance. And I thought that was quite an interesting point. So in their particular case, they reiterated to every witness, this is the final merits hearing, this is really important for the parties, just to reiterate that this was important and real, even though they were sitting in their home. And finally, a lot of the points about the points that Ravi was making about his case in the UK also apply to international arbitration. So I'll just add a couple. I think on cross-examination, I completely agree that, like Bob said, credibility, I mean, I think people, that's just the traditionalists getting a bit concerned. I think I would say in investment treaty cases, credibility can really be a central issue. And the ICC Commission's report on technology does say that you need to make sure that you can ensure there's going to be no illicit interference. And I think we do have things like 360-degree cameras that we could use. And again, I think when you fast forward post-COVID-19, you will probably still be able to have someone there in the room with that witness anyway. Counsel being separated is obviously also an issue in arbitrations. Ravi's touched on that. So the only additional point for international arbitration that I would mention that I think is interesting is tribunal dynamics. And so there could be a potential downside to tribunal members that are located in different parts of the world not sitting together, because a lot of progress is actually made when you're sitting over coffee, lunch and dinner, things like that. So that's my points. And I just wanted to finish by saying that it's great to see that so many people are interested in this topic, and also that hopefully most of you watching are also innovators, and that we're going to be embracing change and being part of it. Thank you.
Thank you, Lauren, Ravi and Bob. That was, I'm sure everyone will agree, that was some really fascinating insights, and I find myself moving around, which I'm now very conscious of. So if anyone, we've got some time for some questions now. So if anyone has, we've got some coming through already, but if anyone has any additional, please just put them into the Q&A box at the bottom of your screen and we'll hopefully have time for them. So to kick us off on the questions, the first one is, we've got a question about whether the panelists believe that now that we're kind of really embracing doing hearings via AVL, is the time to begin to run, say, PowerPoint slides alongside opening argument submissions, things like that, as that would the enhanced impact of having a PowerPoint slide as well as simply your voice speaking might be a game changer. So I think that's probably a question generally for the panel. So whoever would like to speak to that one.
Well, I'll have a go at it. I think that any method which you believe will get your submissions across to the decision maker should be left to you. And I can see that PowerPoints could be a very useful way to accompany oral submissions. I think, at least under the New Zealand tradition, we also have a very comprehensive written submissions, and I wouldn't see PowerPoints as a substitute for those, but rather something that complemented them.
Thanks, Bob. Lauren, Ravi, did you have anything that you wanted to add to that?
Well, I think it really depends on which court you're in front of. I mean, certainly as far as the UK courts are concerned, a PowerPoint would be unique, but in the arbitration context, much more common. I don't see why in the arbitration context it couldn't be an effective tool, particularly in the present climate.
Another question we've got is, how do you convince, or whether if you had an experience of having to convince clients who might already be a bit wary of arbitration as a dispute resolution mechanism in the first place, Have you faced an issue where you've had to then try and also convince your clients to do them via AVL? And have you found that tricky to kind of convince them to be innovators at the same time?
Well, if I could just turn that slightly to one side, I've definitely had plenty of resistance to AVL from lawyers, rather than, I've never got beyond the lawyers to the parties, but the legal profession is very conservative and takes a long time to pick up on a new idea. Mediation is a great example. It took about 20 years for that to become mainstream. And in the same way, AVL is something which lawyers, many of them, will be fearful of because they are not used to it and they'd rather opt for traditional ways of doing things. But it's an ill wind that blows no good, and COVID has actually catapulted us towards AVL, and I think will result in much greater understanding.
Thanks, Bob. We've got a question for Ravi. How did you find the process of re-examination during the financial list trial? It would obviously be much harder to prepare for with all of the team in different rooms. Did the judge give counsel time to consult as to what to ask?
I'm not sure it is actually that different from when you have a physical trial. Provided you've got a line of communication between counsel, then all you do is, while the cross-examination of your witness is going on, you try and pick up points for re-examination. Also, if you have the benefit of a transcript in real time, which you can access via a hyperlink, that's very useful, because then you can just look back at the transcript. You can cut and paste bits from that into whatever communication platform you're using between counsel. It's actually very efficient.
Thank you. We've got a question about the using, Bob, I think you referred to the use of separate devices. And have any of the panel used separate devices for viewing documents at the same time during a remote hearing? And is that something that you found you would recommend?
Well, I certainly do myself. Even without an AVL hearing, I've always thought it important as a matter of one-upmanship to have more screens than anyone else in the room. And that would involve at least 2 laptops associated with a laptop, an extra laptop monitor. And that enables you to have your own personal note-taking, another one for exhibits, another one for real-time evidence if that's being transcribed, and another one for the electronic bundle that everybody else is using. But the AVL adds another dimension, because of course then you have a participant's screen, and you also have a shared screen which somebody, whether it be yourself or a lawyer, is controlling. So that adds up to an awful lot of screens, which I welcome personally, because I have an obsession about looking at screens. But I think, being sensible about it, I wouldn't want to go into it on any basis with less than 2 different devices, even if the screen that you're using, one or more of them, are large enough to divide into separate panes.
Thank you. I'm sorry to those whose question I haven't been able to ask. I'm afraid we have run out of time for questions, but I hope everyone found that a useful webinar. Thank you again so much to our speakers for their fantastic insights, to AMINZ for putting on this webinar, and to AUT for its continued support. I'm now going to hand this back to Sue to close us out. Thank you.
Thanks so much for that, Emma. And I'd just also like to say thank you, obviously, to our speakers, but also to you and to Sam for the enormous amount of work and volunteer contribution that you've both put into making this happen. It really doesn't go unnoticed, and I think that should be recognised. So well done to you both, much appreciated. Now I'm now going to attempt, using my not so exceptional Zoom skills, to try to share my screen and give you a shameless bit of promotion for the Institute. So without further ado, let's just see, well, that's a bit of further ado right there. See if I can pop back in here, because I've managed quite successfully to open my, oh dear, this is a perfect demonstration of what the webinar was talking about tonight, isn't it? Never let a toddler run with scissors in the field of audio-visual presentation. Here we are, once more with feeling, and up onto the screen, and here we go. There we are. You can see why they shouldn't get me near these wretched things, hey? Right, so from the very beginning, a very good place to start. Go, there we are. Right, welcome to the wonderful world of AMINZ. Oh dear. Student membership. Gosh, this really is the most appallingly ugly presentation at this point, isn't it? Student membership is available through AMINZ. Here's the next part. So is associate membership. Look at that there. You'll note that the Koru Club membership is still available, and fellowship this year is also available. We're also doing the fellowship examinations this year, and we would encourage those of you to apply. Registrations are now open for the AMINZ Fellowship Program, and for all other information, please contact the people at the Institute who actually know how to drive one of these beasts. That is not me. On that happy note, thank you very much, one and all, for joining us this evening. It has been an absolute pleasure hosting you. I do hope that the rest of your night, or day, Ravi, is warm and you spend it in your bubble with those who matter to you most. On behalf of the Institute, good night.